So we wrote a blog describing the differences between administrative penalties under the immigration law and criminal penalties under the immigration law, and how they might apply to the issue of decriminalizing border crossings. We have three bodies of law in the United States. There's criminal law, which is what we usually think of as crimes in the United States: burglary, assault, murder, theft, those kinds of things. And that criminal justice system is overseen by the criminal courts in the United States, the judicial courts at the state and the federal level. It also is overseen by prosecutors and public defenders, and of course the law enforcement agencies and jails. Then there's the civil law of the United States. Civil law is those laws that relate to how individuals interact with each other. So major bodies of civil law include family law, contracts law. Those are places where when people have disagreements over their interactions, they can go to court and ask the judge to decide who is right. In those cases, the judge may decide that the person who's in the wrong has to pay a fine or some sort of reparation to the person who's in the right. The third big body of law is what we call administrative law. And this body of law is the body of law that governs how the government interacts with individuals, that it regulates their activities. So some major bodies of federal administrative law include environmental law or tax law. Immigration law, for the most part, is that third category. It's administrative law. But there are some pieces of immigration law that can be prosecuted criminally, and it's those intersections that are in the subject of debate about what to do about people crossing the border. Some Democratic candidates have proposed eliminating criminal violations of the immigration law relating to people who cross the border illegally, those who cross between the ports of entry. So currently, in addition to being deported, which is an administrative penalty, the government can choose to prosecute somebody for illegal entry in the criminal justice system, where they could be subject to time in jail and or a fine, and then be deported under the immigration system. The people who are proposing to eliminate this would still have the administrative penalty. These people would be deported, but they would no longer go through the criminal justice system. And some of the arguments in favor of this are that an increasing number of cases in our federal judicial system are immigration cases. They're taking up almost half of the federal judicial resources in terms of looking at these cases of prosecutions. And an awful lot of people going into federal prisons are going there because of these immigration violations. And it's not been proven that these prosecutions are actually deterring people from coming into the country. So it seems to be an additional burden and expense on the government and not a lot of return in terms of deterrence. However, other people have argued that having these in law allows the government a flexibility to use these provisions when necessary to go after people, for example, smugglers, where they can't necessarily prove a smuggling case, maybe because the migrant witness has decided not to work with them, but then they can use these sections of law to prosecute them and hopefully deter them from smuggling in the future. This is a debate in the presidential election, and it's a debate going on in the public right now. But fundamentally, it comes down to understanding that immigration law is mostly administrative. Some pieces can be prosecuted criminally, and just because we're saying decriminalizing border crossing, it doesn't mean that there's no penalty. These people would still be removed. It's not being made legal.